Are you a family caregiver or an adult wondering about the difference between power of attorney and guardianship? There's a big difference, but it depends on what perspective you're looking at the difference from. Are you the person in the role of the power of attorney agent, or are you the guardian? Or on the other hand, are you the person who has a power of attorney agent, or the person who has a guardian? I'm Pamela D Wilson. I'm a caregiving expert and advocate who has served as both guardian and power of attorney for many clients. And I'm here to explain the differences from both sides of the table. So if you are a person who's an adult and you are doing your estate planning and you are doing your power of attorney documents for medical and financial, which is a very, very wise thing to do, and you name an agent and you think, well, would there be any situation where this agent may need a little bit more power? Like, for example, if I got Alzheimer's or dementia, and I really couldn't tell my agent what they wanted. Because in a perfect world, a power of attorney agent is kind of like an advocate or a representative for someone who maybe needs a little bit of help managing their money or making healthcare decisions. Powers of attorney have to use what's called substituted judgment, which means you do the thing that the person you were appointed for would have done if they could do it. If you're a power of attorney agent, you just can't go and do things that you want to do that this person would have never done, spend their money in ways they would never have spent it, use the money on yourself. Believe it or not, a lot of crazy things happen because people don't understand their role as a power of attorney for medical or financial. Then on the other side, let's say that you are doing your paperwork and you're saying, well, yes, if I ever have dementia or Alzheimer's and I really can't make decisions, then I definitely want a guardian. And I want my person who is power of attorney to be my guardian. Well, then you put that in your documents. But then let's look at guardianship. So if you're appointed a guardian for somebody, it's a very high level responsibility that is usually done through the probate or the chancery court system. There is paperwork, there are filings. The person who you are being appointed for as guardian, normally called the ward or putative ward, they can object. And sometimes when they have Alzheimer's or dementia, they do object just because they don't know what they're objecting to, right? So you're placing yourself in a position where you're having to make decisions for someone who, under most circumstances probably is going to be okay with that. But under some circumstances, they may not be okay with it because maybe there's other family members who are saying, well, Mom or Dad, you should have never appointed Jane because, Bill or Bob would have been a better choice. Or there's all these crazy disagreements in families, right? So if you're ever going to be a family guardian, it can be a blessing, it can work out wonderfully, or it can actually be a very contentious nightmare situations. And in many of those situations, that was when I was appointed to be a professional guardian because I used to do that in another role in my career. Now let's look at the side where you are the person. Let's say you appointed a power of attorney agent. And your power of attorney agent is doing a good job. You're happy. Everything's going well. No issues. But let's say it's just not working out the way you thought. And your power of attorney is ignoring your wishes. They're doing things with your money that they shouldn't be doing. They're causing problems in your family. They're telling you that you have to go to assisted living when you really don't want to go, and there's nothing wrong up here. You don't have Alzheimer's or dementia. There's nothing wrong with your decision-making power, but they're taking over your life. You can actually revoke those power of attorney documents. You can get that person out of your life. Now, the hope is that you appointed a successor in that first document so that you don't have to create new documents. But if you didn't, you can always go back and preferably to the same attorney to create a new document, fire your previous power of attorney, and hire a new one. Now let's look at guardianship. This one may not be so easy if you chose the wrong person, which does happen sometimes. Sometimes parents feel like they don't have anybody else to choose, so they choose one child who wasn't really responsible all their life or didn't really show up. You know, there are professionals that people can appoint who are outside of the family, who are, I don't want to say more likely, but possibly more likely to do the things that they're supposed to. Now, so when you give someone guardianship or conservatorship, different names, different states, you're giving them absolute decision-making power over everything. A bad guardian or a bad conservator can do whatever they want with your life and where you live and your health care and your money. And it happens because I serve as an expert witness in these types of litigation cases. I know. A bad power of attorney can also do the same thing. But guardianship is absolute. So let's flip it around and say that you're the guardian and you're the family guardian. Well, you have reports to do for the court about where this person lives and how their health is. If you're responsible for money, you have financial reports due to the court. You can't just say, oh, you know what, I'm going to use this money for my own benefit. I'm going to take a trip. I'm going to do this. No, 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 no. The money has to be used for the benefit of the person that you're taking care of. So you don't get to use it the way you want. You have to use it for their benefit. And it can get kind of interesting in families if your siblings are really interested in your parents' money and their inheritance, and you're the one charged with saying, nope, I have to spend it on their care. They're going to get the best care. I'm going to put them in a very nice assisted living, a very nice memory care, make sure that they don't want for anything. Your siblings may be throwing a fit because they're going to be like, well, there's going to be no money left for our inheritance. But that's what your parent deserves. So there's huge differences between power of attorney and guardianship or conservatorship. And there's even bigger differences on the side of the issue where you might land. You appointing somebody to act in these roles for you and trusting that they're going to do the right thing, or you being that appointed power of attorney and guardian or conservator. And I know this because I served in these roles for 11 years in a professional capacity, and today I counsel families on these topics, and I serve as an expert witness in litigation cases related to conservatorship, guardianship, care management, elder abuse, persons with Alzheimer's and dementia, and home care. So I thank you all so much for being here for this video. You can visit my website, PamelaDWilson.com, for more information on any of these topics. Below this video, there are links to my bio, my expert witness page, ways to schedule a one-on-one consultation, and other helpful information.